The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. 4 cases will be submitted this afternoon. Those cases are Sandra Irving versus Employment Appeal Board. Second case is Iowa Supreme Court Attorney Disciplinary Board versus Jason McCleary. Third case is United Suppliers, Inc. versus Rennie Hansen and others. And the final case is State of Iowa versus Chauncey Lewis. The last 2 cases are now submitted to the court without argument, and we'll hear the arguments in the case of Irving versus Employment Appeal Board. Ms. Diehl.
All right, may it please the court, opposing counsel. My name is Alisa Diehl, and I represent the petitioner Sandra Irving. Iowa Workforce Development was wrong in denying unemployment benefits to an innocently jailed claimant, unemployed through no fault of her own. And as such, Ms. Irving is entitled to unemployment benefits under Chapter 96 of the Iowa Code. Ms. Irving is asking this court to reverse the district court decision denying her claim for benefits. Ms. Irving's claim for benefits was denied after she was unemployed involuntarily, after she was arrested and jailed on 2 felony criminal charges that were subsequently dismissed without conviction. Ms. Irving was denied benefits by Workforce Development under both a voluntary quit theory of analysis and a misconduct theory of analysis.
Could you first address the mootness issue? The board contends that because she was terminated for misconduct from her part-time position, that disqualified her for benefits. She didn't appeal it, then it doesn't make a difference what we do on this appeal.
Certainly, Your Honor. First, it's the petitioner's position that her case is not, in fact, moot, per Welch and McCarthy. In both those cases, separation disqualification did not apply to a claimant's primary or regular employment.
Now, those were both voluntary quit cases. Does their reasoning extend to misconduct termination?
The reasoning behind them does. I pose an example. A claimant like Ms. Irving, who has 2 concurrently held jobs, one is a part-time job, one is a regular full-time employment. She's disqualified, or she's terminated from the part-time position for misconduct. A week later is laid off from her primary employer, and she would be held ineligible. That seems like a result that the statute did not contemplate when she was in fact employed until she was laid off from her regular full-time employer.
In the alternative, you argue that this case is, we should look at or apply an exception to the mootness doctrine because of its public importance, or that it's a recurring issue capable of evading review, right?
Correct, Your Honor.
But why are other cases likely to evade review? It seems unusual that you'd have this combination of two jobs and terminations.
It would evade review because the class of claimants that this applies to, people who are unemployed, who are so often unrepresented, would fail to have access to, at the very basic level, preserve the record, would know what issues to bring even. When the administrative law judge is saying, we don't care whether you were convicted or not, or whether you committed these crimes, we're not going to hear any evidence about it. And so without representation to make those findings and that factual basis in the record, It would be an access to courts issue, simply.
And that may explain why, even though this incarceration rule has been on the books for nearly 40 years, our court hasn't addressed it yet.
Correct, Your Honor. I would also agree with that. Again, it's unsurprising because of those same reasons, an access to courts issue, why this has never been challenged before. But I will note that many other states have had similar distinctions as the one that the respondent is putting forth today, and that there is no culpability finding necessary in a voluntary quit based on incarceration.
Ms. Diehl, with respect to that voluntary quit issue, isn't incarceration voluntary when the act resulting in incarceration is voluntary?
I would concede that yes, incarceration is voluntary when there is some culpability on the part of the claimant, whether that is committing a crime, violating a court order. Certainly then incarceration can be said to be voluntary, and thus missed work based on the incarceration would be a voluntary quit, but that would require a factual finding.
But doesn't the rule that sets that out as a presumption allow the employee to come in and show otherwise?
No, the rule is per se disqualification. If you're incarcerated, you are, as a matter of law, you have, as a matter of law, voluntarily quit. And so there is no room to provide information or evidence of culpability.
But doesn't that make a little bit of sense? That why is it the employer's responsibility to look behind the reason and the purpose of why you're incarcerated, why you're not working, I guess is my point. Why is it the employer's responsibility to do that?
The employer has the option whether they discharge a claimant. So they could choose, if they don't want to go down that road, to hold the position open until a criminal case is resolved.
Well, what about the circumstance with in this particular case, if you're sitting in jail, why don't you just give your employer a call and tell them, something's come up, I can't come into work the next 10 shifts that I'm supposed to be working?
Well, in this case, Ms. Irving's mother did call on her behalf. She called her employer until the employer told her mother to stop calling. So she did report.
That was disputed, I think, wasn't it?
There was no evidence otherwise, other than the mother's testimony, certainly.
Are you suggesting then we need to have a criminal case within an unemployment hearing? The general structure, I think you'll agree, is one of some expedition ordinarily. Do you think the rule could be justified on the ground that, look, we're not going to end up with criminal trials on culpability matters, that's just inconsistent with the administrative structure of providing prompt hearings and remedies for unemployment?
Perhaps, but there are many other jurisdictions who have this exact distinction. In fact, states with larger populations than Iowa, who I think if you would look at the websites for their agencies process even more claims than Iowa Workforce Development does, who find a way of balancing the fairness to the claimant in terms of culpability.
If a finding of culpability were made, would that be issue preclusion in later litigation, do you think, against your claim?
I think that would be a question best addressed by a claimant's criminal attorney down the road, I would suppose. But it is an administratable distinction, I believe. I would, of course, leave that up to the agency to put out for rulemaking, but I think it's possible that it's done. Now, at what threshold, what's required, that's not this case. I would leave that to them, but it certainly is possible, and in fact, I believe required. The rule at issue here creates an absolute presumption that arrest followed by custody is per se disqualification. And to that end, it redefines voluntary to not require a volitional act or any foreseeable consequence in the context of incarceration.
Can you just tell me on what authority you base your opinion on, that they cannot make it a per se violation? I mean, is that an interpretation problem, or is that a beyond the scope of their authority problem? I mean, what's going on with that?
It's potentially both. I think first and foremost, it's beyond their authority because they took an ordinary word and completely expanded and enlarged its definition to include things that are the exact opposite. Clearly, it's an interpretation issue as well. Otherwise, I don't think we would be here.
What's the ordinary word? I mean, don't we have to look at voluntary quit together? And is there any other statute in the Iowa Code that uses that term?
I think most importantly is the word voluntary. Because
But we can't look at it in isolation. It's voluntary quit. That's the issue. And we have an agency that's been in charge for some decades of a very complex regulatory scheme. Shouldn't we defer to that agency's expertise in statutory interpretation?
Not on this limited matter, Your Honor. The legislature did not give the agency the authority in this context to interpret the words of the statute, particularly when that interpretation has exceeded the common meaning and just requires the exact opposite of what the actual statute says.
Ms. Diehl, so we're dealing with this interpretation of voluntary quit in the statute. Mr. Autry makes the point that if you look at the statute, after saying that a voluntary quit, it in general disqualifies you from getting, unemployment benefits, the legislature then went on and said, but the following shall not be disqualification. And then they list a long list of things that really probably by, a layperson's view might not be considered voluntary at all. Doesn't that suggest that the legislature intended the phrase voluntary quit to have a broad definition?
Well, the examples, I don't believe so, because the examples that are provided in the statute are actually one that is completely analogous to the situation here, and that's when a claimant is ill, can't come to work, and is then only eligible for benefits once they have recovered or are able to work.
But if that's the case, then shouldn't the legislature have made an exception for incarceration as well? If you say that these exceptions are analogous, then you run into the problem the legislature didn't make the exception you're asking for, right?
It did not, but it couldn't contemplate, I think every possible iteration of the complex and particular issues that may come before it, and left that to the agency to do that within the meaning of the statute, within the meaning of the words that the statute does contain. And it's our position that requires a voluntary aspect to it.
Couldn't we strike down the rule that makes it a per se voluntary quit if you're incarcerated, but then find under these facts that your client voluntary quit on a number of bases? Number one, she did this conduct, or number two, she had a right to bail and didn't get her bail. I mean, it's not like she was, forced to stay in jail, because bail is allegedly set, in a reasonable manner. So, so I see we have two issues here. That one, is the rule okay? And let's assume it isn't. Where does it get you?
If the rule is not okay, then the next step of the analysis, as you say, should be the misconduct analysis. However, similar to a voluntary quit analysis is that there is a requirement of intent, and that has been made clear time and again, both under Iowa case law, the definition of misconduct that was promulgated by the agency and ratified by this court, and that there must be some sort of deliberate action or recurrent negligence so as to show ill intent. That's been clear time and again. And so, yes, I agree. There are two steps here, but both require an intentional and volitional act foreseeability that unemployment is going to follow, termination, I should say.
To rule in your client's favor, would we need to overrule our line of cases involving personal responsibility where somebody misses work because their car breaks down, their babysitter doesn't come, the bus is late, and our court has upheld disqualification on those grounds? How is this different?
Your Honor, I do not believe that those line of cases would need to be overruled. In fact, I think that this scenario fits nicely into that line of cases. Intent and foreseeability are what couch personal responsibility cases in misconduct, quite simply. What makes it reasonable to deny benefits to a claimant under the purpose and intent of Chapter 96. The hypotheticals that have been proposed by Mr. Autry and the line of cases are different than the case here for a number of reasons. First, when you have a child, you have to decide what to do with the child when you go to work. If you don't live within walking distance of your job, you have to figure out how to get there. And that's reliability of transportation, that's inclement weather, that's traffic patterns. These are the necessities of everyday life that we all have to organize. And when you don't organize them, and you are warned by your employer repeatedly about failing to organize them, you're then terminated. That is foreseeable, and it's foreseeable that that would be misconduct. Thank you.
Thank you as well, Ms. Diehl. Mr. Autry.
May it please the court. I guess I'll start with the mootness argument. I have my argument set out, but based on the questions, the mootness argument is worth discussing on the McCarthy-Welsh, in large part because the argument they're making on this, that if you get disqualified from part-time work for misconduct, then you should only be disqualified for benefits, wage credits earned from that job, that part-time job where you committed misconduct. That's probably, in terms of how the system's administered, the most disturbing argument that they make. The way that fund is administered is administered on the assumption that's been in the statute for many, many years, that if you're disqualified for misconduct, even from part-time work, you have to earn the minimum 10 times your benefit amount in order to requalify. The only exception that's been there is a regulatory exception for part-time work for quitting. And the McCarthy-Welsh cases, you look at those cases, what they're about is, do you punish the person for being too industrious? In particular, in the Welch case, they were working during their benefit year, and then they quit the part-time work during their benefit year. So you work during your benefit year, you get partial benefits. Your wages have reduced the liability of the employers paying your unemployment compensation. So the claimant found out, well, it's too hard to look for work and work part-time, so I'm going to quit. And the court said, that shouldn't be, you shouldn't disqualify them for quitting that. They should, during the benefit year. It's a different thing when you're talking about misconduct. Number one, the code sections you look at, I go through the history in my brief. There's no way you can interpret that history as saying that you're going to do anything but a full disqualification for misconduct cases. Number two, you can easily imagine cases, and they wouldn't be rare, where someone commits misconduct in a part-time job that's not in their base period. So you don't reduce their unemployment at all. But imagine what you will. Sexual harassment or whatever would constitute misconduct they did. But they lost employment. They had a part-time job. They lost employment in the part-time job. Then they filed for benefits or reactivated their claim after the part-time work. And they committed misconduct. And the reason why they're not in that job is misconduct. It doesn't reduce their benefits. So it's not a fair rule. And it's not, the McCarthy-Welsh rationale simply does not apply in misconduct cases. And it really creates an issue for the fund, because the fund assumes in those part-time cases that if it's misconduct is proven, then you're not going to get benefits until you've requalified. So that's my point on the mootness. The voluntary leaving issue is...
Can I ask you a question about the rules? It's my understanding, and maybe I misread it, but I thought you agreed that it's our duty to interpret the statute and not the board's duty to interpret the statute.
Well, I would say that the workforce development interprets the statute. And in this case, the regulation interprets the statute consistent with the Supreme Court's...
We're under our Renda decision. Does the board have authority to interpret the statute?
Did you say under the Renda decision?
Yes.
Well, where the board agrees with workforce, what we're talking about is workforce. I would say since in 2005, in the Hy-Vee case, you'll recall, this court reversed a Court of Appeals precedent because the Court of Appeals precedent was inconsistent with an agency regulation. At that case, it's 05. There's been no statutory change.
Has that been before Bondsfield's or after Bondsfield's amendments to the...
After. That's 7 years later. Those amendments are 1998. That case is 2005. In 05, you reversed the Swanson case by relying on an implication that what the Swanson rule had been in the Hy-Vee case. That Swanson rule was repudiated by the regulation, and you relied only on the regulation and no additional analysis.
Since that time, we sort of backtracked and Renda and have a stricter test.
Yeah, it would seem, but what I'm saying is even under that test, there's, well, number one, we have precedent. Number two, under that test, and the question is, and interestingly in that case, that was brought by legal aid, so legal aid now is arguing the exact opposite of what they'd argued there. Is the Hy-Vee rule going to go away? Are we going to have a different ruling in the Hy-Vee case if we decide that it doesn't get deference, there having been no statutory change? Those are some issues. But let me say this. There have been 2 Court of Appeals decisions since Renda that have given us deference based on that phrase in the statute, if so found by the department, which is repeated all throughout 96.4 and 96.5, so one place in the 4 and throughout 96.5, which can only mean, it can't mean that it's giving adjudicatory power to the department because 96.6 does that. You wouldn't need to do it twice. So it says right there, voluntary left doesn't actually say quit. Voluntary left.
What special expertise does the agency have, though, in defining voluntary?
Well,
I mean, that's really what the key is. I mean, if it's a term that's used in the code, I mean, it's normally our job to interpret the statute.
Well, well, for one thing, the one thing that's getting overlooked, I think, in a large measure, is that the phrase isn't voluntary. It's voluntary left with a good cause attributable to the employer. 1948, this court in the Moulton case ruled that a pregnant woman who quit her work because she had restrictions that made it so she couldn't perform her job, she argued that's not a voluntary quit. Justice Bliss, writing for the court, said, you know what? That was a quit for personal reasons. The statute originally did not have in it, attributable to the employment. And that phrase has to be kept in the statute, and you have to read all together, voluntary left without good cause attributable to the employment. The court ruled in the Moulton case that when you leave for personal reasons, that's voluntary within the meaning of this statute. 5 years later, 1953, the Wolf's case, a claimant left work in order to take a family member to Arizona because their sinuses were acting up and they could breathe better in Arizona. So they left for the purpose of taking a family member to a different climate, argued not voluntary. Supreme Court, yes, it is voluntary within the Moulton rule. That's 1953. 1961, the legislature amends the statute. Now, does the legislature amend the statute by getting rid of voluntary left and saying left of own volition? Do they change 9619 and put in 9619 a definition of voluntary? They do not. What they do is they amend the statute to put in a section saying if you leave for the purpose of taking a family member to a different climate, that's an exception to the voluntary leaving. That would normally disqualify you. It would normally be voluntary leaving without good cause to the employment. But an exception to it is if you take it to a climate. Thus, codifying the Moulton idea, they also put in 9651D. The climate case never comes up. I've never seen a climate case, but 9651D.
Can I interrupt? Let me ask you about a general topic. Ms. Diehl, in her brief, lists a number of other states where if the individual is incarcerated but charges are ultimately dropped or the individual is ultimately acquitted, they do get unemployment benefits, which you contend is different than the rule that applies in Iowa. Now, normally, when the appellant cites a bunch of out-of-state cases, normally the other lawyer comes back and says, yeah, but those cases are distinguishable, and here's why, and here's some cases that go my way. I didn't see any of that in your brief. So what's your response to this out-of-state authority cited by Ms. Diehl?
We base our interpretation on 67 years of this court's interpretation. Moulton, Wolf's, the area residential care facility, the amendments made to the statute, in effect codifying that version of what the word voluntary means. Also, there's real practice. No way of looking at those cases. Number one, I looked at a number of those jurisdictions. A number of them do have rules or statutes that are different, and therefore they're in a different regulatory scheme. Also, in the standpoint of the practical effect on the employers. You know, who can compare what tax rates employers are paying in those states versus what they hear, how healthy their fund is versus ours? Who knows? But the practical effect it has in Iowa is complicated by several things. One that perhaps is not in a different state, and I wanted to address this issue that it seems like a good idea. And it's such sort of a judicial approach to it. What if it were just a presumption? And we did say they're presumed to have voluntarily left without good cause to the employer. It's presumed not to be an excused absence, but if the claimant come back later and can prove that it was excused, then it should be voluntary. Suppose we took that view in Iowa. Our problem is twofold. Well, it's multifold, but the one problem is, do we just let the claimant come and say, I didn't do it? Is that sufficient rebuttal? If the employer says, one of our 55,000 a year fact finders is conducting a fact finding, and the employer says,
In this case, the complaining witness withdrew the allegations,
Well,
which is not uncommon in domestic violence.
Domestic violence case, yeah.
I would accept that, but it wasn't just the fact that charges were dropped, right?
well, I'm talking about as a system, because what we're of course here about is administering a benefit system, and as I say, we have to decide every week, unlock or lock the claim. And so when we look at a claim and looking at the overall system, if we were to have a presumption, would we just let the claimant come up and talk about it? And what I'm getting to is 9611.9 in the Iowa Code discusses the privilege against discrimination, right? And that what it says is there is no privilege against discrimination in an unemployment case. But if you're forced to talk about it, you get transactional immunity. So if you create a presumption that the claimant, if they're in jail, they're presumed that they're going to be disqualified unless they can prove they didn't do it. And you're going to get that just, instead of getting independent evidence of it, as we did in this case. You ask the claimant, did you do it? And the claimant says, well, yes or no, or it says, my attorney tells me not to talk about it, which is not uncommon. We do hear that.
What about the presumption of innocence? Does that play any role?
The district court said no, it did not. It's in a civil case, and the claimant hasn't. I footnote. I don't address this because the claimant just didn't make the argument on the presumption of innocence. So I think they've waived that issue. But the incrimination, the problem is if you just let the claimant talk about it, you're talking transactional immunity, and some of these cases are pretty serious crimes. So you're putting in the hands of the unemployment system whether we're going to give transactional immunity to claimants by forcing them to talk about whether they did the crime or not. If you're talking about using independent proof, the question is timing. If we have to wait for that criminal case to come through, not only is there the delay in the system, in a system that's under federal timing requirements, but there's the overpayment issue. I mean,
You know what's kind of interesting here, though, that people are required to remain in jail pending the outcome of a criminal case, largely because they can't afford to post bail, since almost all of criminal offenses are subject to bail. So, but then the law uses this incarceration as a voluntary act. So it seems to be a law that applies disproportionately to people who are unable to afford bail. So if that's the difference between a voluntary quitting and being able to show up for work the next day after you've nevertheless been arrested for a criminal offense, how can we use that distinction to determine the issue of voluntariness to quit?
Well, I think the question is a general point in that source of income or not having enough income. There's a lot of rules in the unemployment system that have been approved by the court that can have a disparate impact there. I mean, that's why I don't think the Supreme Court has found that to be, what was it, the Rodriguez case? They found that isn't.
But doesn't that mean that not being able to show up for work the next day really isn't whether it's voluntary or not? It's whether you can afford to post bail.
Yeah, but somebody who can't show up because they don't have transportation because their car broke down, isn't that just because that's what I'm talking about. Isn't that just because they can't afford a better car or they couldn't afford maintenance for the car? Ultimately, the employer isn't going to pay for that because it's not an excused absence. I mean, so that's not at all uncommon that a lack of money affects, as a practical standpoint, whether someone's going to be able to meet conditions that'll allow them to satisfy the employer's job conditions.
Well, in that case, though, it's not the arm of the state that's involved in the process. It's as Ms. Diehl said, it's simply the everyday facts of life sometimes will intervene. But
Yeah, I think if she'd have bailed out and the employer had kept her going, we wouldn't even be involved in the case. So for us, it's if you're out, you have to be in jail long enough for the employer to fire you over it. Or not fire you, but what they do is they code it as job abandonment. Because typically the employer doesn't know why they're not there. But on the timing issue, let me just say, if we do pay benefits, and I would cite to you the Java case, United States Supreme Court, 1971, you have to have some basis to deny benefits. So if we waited on a presumption and we said, we're going to presume that you're not going to get benefits, but we'll wait. We'll wait 3, 6, 5, 8 months for the criminal case to work its way through to find out the answer to this case. The person's going to be paid benefits in the meantime. And we're going to have this enormous overpayment. And the person is never going to, and you're going to end up, even for people who are guilty, you're going to end up having funded them that period of time until they're found guilty. It's not really a practical approach to the problem because of that. There's also just problems of administration, problems of telling sending out the quarterly statement of charges to the employers. They won't know for so many months. And some of these smaller employers, a single employee can make a big difference on their tax rate.
Do your rules address those overpayment instances where there's a recovery mechanism?
Yeah, the recovery mechanism is quite limited. In fact, it's the great majority of overpayments are not recovered. The recovery mechanism is only twofold unless you show fraud, and that would be that you can, there's like lottery winnings, but obviously that doesn't come up very often. But you can recover future benefits, and you can recover income tax refunds. And when you're dealing with unemployed folks, you just don't see either one of those very much. If you start claiming for future benefits, and the state starts taking your future benefits, guess what you start doing? You don't do. You stop claiming for benefits. So you just move to another state. So the recovery of overpayment in general is not very successful. And when you're dealing with someone who's going to be in jail because they're convicted, I'm saying assuming someone's convicted, we're never going to get that overpayment back. And what we end up having is the fund is presumably be paying for it. And then not to mention the problems you have with charging employers in cases such as this, where the person's entire reason, I would not say their entire reason. I mean, we do have her doing a false 911 call, so the police did show up because of her false 911 call. So it's not as if she has no responsibility for what happened here. She was convicted of that. So she falsely called the police, then someone falsely made charges against her. It's not as if she's completely innocent as a newborn babe in that situation. But even if she were, the employer ends up paying for it. And the board doesn't really have the authority to just relieve the employer of charges. There has to be some statutory or regulatory authority to do so, and there just isn't.
You may sum up, Counsel.
Thank you, Your Honor. Well, it was a rare pleasure to be here today, and I would I haven't been here in 10 years, so maybe another decade I can get another 15 minutes. Thank you, Your Honor.
Mr. Autry, thank you as well. Ms. Diehl.
Thank you. The first thing I'd like to address that Mr. Autry discussed was the possibility of paying benefits to a claimant who is ultimately found guilty or culpable in some way if a criminal case isn't resolved before the unemployment claim can be adjudicated. And I'd just like to point out that the purpose of Chapter 96 is to minimize the burden of unemployment on people who are unemployed through no fault of their own. And it's structured so that the best person or best entity who's in a position to take the burden of that is the employer, quite frankly. And quite simply, the statute does not require that there is a fair administration to the employer. And as I say, they are in the best position to take that brunt. It's not going to be the end of the employer, but it may well be.
An economist would say, or even someone who's not an economist like me might say, if the employer has to provide benefits and unemployment insurance rates go up, what you're required to pay as the employer, then that in the end reduces the overall level of employment because the employer has to make, there's sort of an additional cost associated with employing people, right?
Potentially, but the employer is in the best position to bear that burden, and as I say, the balance of the fairness between the two, even when an employer is not at fault. For example, in the case of a layoff due to bad weather, is to be held by the employer.
In this case, the employer is a branch of the state of Iowa, so it would be taxpayers of Iowa who would bear that cost, right?
Well, the balance would be to determine as efficiently as possible the cases where those benefits are paid out correctly. So in the percentage of cases where that's not possible in an easily efficient way, paying claimants before a finding of culpability is on balance the fairest way.
How do you respond to the board's argument that the legislature has tacitly approved the incarceration rule that's been on the books since 1976? The legislature has made a number of amendments, but has not overruled that interpretation or that rule.
Well, my response is twofold. First, I would again go back to the fact that the majority of these claimants, or all of these claimants, are probably not in a position to be able to afford representation, and so we go back to the issue of making a record and even formulating and understanding the arguments, much less filing an appeal on this issue, which is why it's no wonder that it hasn't made it here before. But again, I think as applied, the legislature didn't contemplate that it would be adjudicated in such a way as here.
Well, from the employer's standpoint, she's not at work from November 28 to Christmas Eve. I mean, she misses roughly 3 weeks. She misses at least 10 or more scheduled 8-hour shifts. Isn't the employer blameless here?
The employer is blameless, and certainly no one is objecting to their right to terminate her employment. What is at issue here is whether she's eligible for benefits. So certainly they're well within their right of firing her when she hasn't been at work. As I said earlier, they certainly could decide not to do so and wait to see how the case played out. But they would be well within their right to do so. But like other situations where an employee is not at fault for the unemployment that they face, such as Bartelt, for example, where the shareholder of the employer filed bankruptcy and resulted in his own unemployment, that burden is put on the employer rather than the employee.
Was there an adverse factual finding that Ms. Irving did not comply with the requirement that she give notice and get approval before she missed 3 days or more of work?
The administrative law judge didn't address that directly. In the record, there is testimony that I guess it's uncontroverted that she did not have an approved leave of absence. She testified she thought she had. I think she was mistaken in that, and that wasn't challenged any farther. She did present evidence, though, that she notified her employer immediately and consistently until they told her to stop. Lastly, I would just like to address Mr. Autry's discussion about how a large number of unemployment regulations fall more harshly on people who are poor, and that's just something we have to accept. But again, I think that there is a difference between, again, a claimant who is physically prevented from being at work, who is held there by the state, who had bond put against her that is beyond something that she can reasonably afford, and people who have to take a bus and are at the whim of a late bus, or at the whim of a car that doesn't work very well without the means to fix it. I think that is a fundamental difference here. Thank you.
Thank you as well, Counsel. Case of Irving versus Employment Appeal Board is now then submitted. And we'll next hear the arguments in McCleary.